I'm very concerned about the debate we're having in this body concerning the exclusivity of the statute we're going to pass. There's been a long history of the debate as to how much Article II power the President has in regards to warrantless surveillance. This is not a new subject. But I must tell you, I think this administration took that issue to a new level. I believe the courts agree. The President went too far. So it's our responsibility to try to get this right so that we have the rule of law behind what the administration does rather than trying to use Article II power, which in fact can very easily be abused. Now there's another issue I want to comment on very briefly, and I'm going to come back to the sunset provisions as to why I think the 4 years is so particularly important in this legislation, and that's the immunity issue and the retroactive immunity. Retroactive immunity concerns me, and I would hope would concern every member of the Senate. It concerns me not just as it affects the telephone companies in their cooperation with this administration, because there's been clear evidence that they operated under the authority that the administration had this power and that they were helping their country. What concerns me if we grant retroactive immunity is the impact it will have on the courts oversighting the abuses of privacy by the administration or private companies. We need the courts actively involved here. We don't get this right all the time, and certainly the administration doesn't get it right all the time. We need the courts involved in these issues. But if we grant retroactive immunity, we're saying, well, we reserve the rights to take away the third branch of government, the judicial branch for government, for making determinations as to whether an individual's right of privacy was violated. I don't think that's something that we want as a legacy of this Congress. Let me get to the amendment, the specifics of the amendment that I've offered, which is the 4-year sunset on the provisions. And again, I'm pleased to be joined by several of our colleagues. It's interesting to point out that sunsets have been part of the FISA statute for a long time. When the USA Patriot Act was passed, it contained a 4-year sunset. Now, why did we put a 4-year sunset in? We didn't think we were worried whether we got it all right or not. Whether this is something that required the continued attention of the Congress and the administration. And in fact, we reauthorized it with significant changes, and then put another 3-year sunset, in this case, on the most controversial provisions. So this is something that we've done in the past. Now, the Protect America Act is a major departure from the Patriot Act. It was passed hurriedly, and no one denies that. It was passed hurriedly last August. And we weren't, again, comfortable with what we did. The proof is that the bill that's now before us is a much better bill. Thank goodness we had the sunset. Now, the committee recognized the need for a sunset because they put a 6-year sunset in it. So why do I think it's so important to change that 6 years to 4 years? Let me tell you why. I think it is in our national interest that the next administration that takes office in January of 2009 be focused on this issue. This vital issue of getting the intelligence information that's critical to protect the safety of the people of this nation, but also to protect the civil liberties of Americans. I think it's vital that the next administration look at those opinions that came out of the Attorney General's office in the White House and give a fresh look to it and try to figure out if there is not even a better way to accomplish both the collection of information and the protection of civil liberties.